All rise. The Honorable Supreme Court of Georgia is now in session. Chief Justice Hugh Thompson presiding. You may be seated.
Good afternoon, everyone, and welcome to this afternoon's presentation of argument before the Supreme Court of Georgia. You'll note that to my left, Justice Harold Melton is not on the bench with us this afternoon. Regrettably and unfortunately, he's had a death in the family, and he is not going to be attending the arguments. We are going to record the arguments, so both with video and auditory, and he will fully participate in this case and all cases that will be argued this afternoon. It's just that he won't be with us physically. Let me ask that each of you take just a moment and render silent any telephone or electronic device that's capable or might conceivably make some sort of interruptive noise during the course of the arguments this afternoon. It is very, very disruptive should that occur. So please put your phones on off or in a silent mode at least, so that we can be careful about that. Let me also note that for those of you who don't know her, Ms. T. Barnes, to my right, your left, is our clerk of court, and her chief deputy is Ms. Tia Milton, to my left, your right. And this afternoon for security, we have Trooper First Class Moses Little and Trooper First Class Kerry Gay. Thank you, gentlemen and ladies, for attending on us this afternoon. We will probably take a recess after the first case to allow the media to break down their cameras and other instruments. But this case will have 20 minutes aside for argument. The attorneys involved in the case be responsible for keeping up with your own time. We do have a recording device on the podium, and we also have one on the bench to help you do that. If you should go the full length of your 20 minutes, we'll ring a bell so that you'll know that your time has expired. Ms. Barnes, you may call the first case.
S15A0011, Hemy Neuman versus the state. Scott Key for appellant, Anna Cross for appellee.
May proceed when ready.
Mr. Chief Justice, and may it please the court, the trial court allowed the state to violate the protection of attorney-client privilege, causing harm to his defense in 4 specific devastating ways. 1, Dr. Peter Thomas, who was hired as a defense consultant, made a notation for which he was cross-examined and for which was used by the state to cross-examine Dr. Flores, who was a defense expert, with a statement attributed to Mr. Neuman, "I knew it was wrong." 2nd, the state introduced both consultants' files in their entirety into evidence and cross-examined them extensively in a way that suggested that Mr. Neuman was malingering. And also, the state used one isolated interpretation of a psychological test to also suggest that Mr. Neuman was malingering. And since the state's essential attack of the insanity defense in this case revolved around the fact or the argument from the state that Mr. Neuman was making up his psychosis, to have introduced anything from a defense consultant, much less 2, suggesting malingering, was devastating to the defense. But the harm that came to the defense from the violation of attorney-client privilege went beyond those 4 things. Just the sequence of witnesses who were brought into the case and suggested were involved in the case, it is natural and it is normal, and defense counsel should be able to develop their case, investigate their case, and build their case on the basis of consultants who were hired as agents for the attorney, who can come in and meet with a client to develop a potential defense. In this case, 2 consultants were brought in to interview Mr. Neuman in the DeKalb County Jail, Dr. Julie Randorney and Dr. Peter Thomas. Both of those experts, it was never the intent of the defense that they would testify. They were brought in strictly as consultants, and I would submit that had those consultants, had Mr. Neuman had a bond, it's likely the state would never have known that those consultants were being used. We are asking for a new trial where the state will not be allowed to use any of the material obtained by the state subpoena of defense consultants against Mr. Neuman at the next trial. In terms of the law, there is no statutory basis or basis in case law for the state to subpoena defense consultants who will not be testifying, even in a situation where the defendant has entered a plea of not guilty by reason of insanity. The discovery statute does not require it. Under OCGA section 17-16-7, only witnesses who are going to testify must have their statements reduced to writing, and only witnesses who are going to testify must have their materials turned over to the state. And under OCGA section 17-16-4B, when an expert is going to testify, that expert must reduce the report to writing, and it must be turned over to the state. There is no discovery obligation for the defense to turn over any evidence of a non-testifying consultant. Furthermore, the entry of a not guilty by reason of insanity plea does not equal a blanket waiver of any and all mental health experts who may come in as a consultant who are not going to testify. And in Estelle versus Smith, the United States Supreme Court held that when a defendant enters a not guilty by reason of insanity plea, there is a limited waiver that means that if the defense is going to introduce expert testimony, then the state has the right to evaluate that defendant and to enter or to call an expert witness, to have that expert witness give the state's expert witness testimony. This court held in the Moats case in 1987 that if a defendant wants to tell his story through the mouth of an expert in an insanity case, the state should have an equal opportunity to tell that story through the mouth of an expert. The state can cite to nothing other than the Rogers case, which we would submit the state has misapplied and misinterpreted, to stand for the proposition that the state has the ability to do what it did here, which was subpoena defense consultants' files, require those consultants to turn their files over to the court, and then have the court turn those files over to the state in their entirety for trial. In fact, the authority actually goes the other direction. Before this case, before the lower court did what it did to Mr. Neuman in this case, one of the most fundamental and basic assumptions that a defense attorney had in exploring his case was that attorney-client privilege would cover not only communications between the lawyer and the client, but also communications between agents hired by the lawyer and the client. In the Ash case, for instance, the Court of Appeals held that the attorney-client privilege includes by necessity the network of agents and employees of both the attorney and the client acting under direction of respected principles, and under OCGA section 24-9-24, communications to any attorney or his employees to be transmitted to the attorney pending employment in anticipation thereof shall not be heard by the court. Attorneys have traditionally been allowed to build the defense, to use consultants, and to learn about the potential defenses in the case without that being subject to subpoena.
Can I ask, the privilege would normally only cover confidential communications between the attorney, the client, or their agents, and then the work product privilege might, get to things that reveal the attorney's mental impressions. Is it clear that attorney-client that confidential communications were disclosed?
Yes, Your Honor. In fact,
Or work product?
In fact, when Dr. Rand Dorney came to see Hemy Neuman for the first time, Mr. Neuman signed a consent for independent medical examination form. That medical examination form can be found in Exhibit Volume 3, page 557. It was tendered into evidence as State's Exhibit 101. And in that consent for independent medical evaluation, Mr. Neuman filled out, or he signed a release that said, when the evaluation is complete, a written report will be provided to your attorney. It begins, you have been referred by Mr. Robert Rubin, who was one of the trial counsel in the case, for an independent medical examination. The purpose of this examination, and it talks about criminal responsibility and psychiatries. Now, there is some discussion in there about the examination not being confidential, but it's not confidential only to the extent that whatever is disclosed will be shared with the attorney, because it is the attorney, not the client, who actually hired Dr. Randorny. And Dr. Randorny brought in Dr. Peter Thomas, who did some testing in the case. So there was an expectation that this was a privileged communication. That expectation was created both verbally by Dr. Randorny when she spoke to Mr. Neuman, and it was created also by the form that he signed. The understanding was, I've been retained by the lawyer, my findings will be shared with the lawyer. And that was the assumption on both Mr. Newman's part, on trial counsel's part, as well as the expert's part. I would like to talk a little bit about the Rogers case because the state relies on it fairly heavily. In fact, the hearing where the lower court heard the motion to quash the subpoena of Dr. Thomas and Dr. Randorny, the state referred to it as a Rogers hearing. I've never heard of a Rogers hearing before the hearing on the motion to quash in this case. And in fact, Rogers is quite distinct. This court held in Rogers versus State in 282, Georgia 659, a 2007 case, that a doctor who was appointed by the court, and the court's direction in that case was that he would be treated as if he were hired not by the lawyer, but by the patient, who was then the client. This was not a situation where attorney-client privilege was even an issue. This was a situation where Dr. Hark, who was the treating physician of the client earlier, had been brought in not merely for an assessment, but in some sort of treating context. Rogers does not stand for the proposition that when a person enters a plea of not guilty by reason of insanity, that there is a blanket waiver to any and all defense consultants who may come and speak to the defendant, even if those people happen to have medical or psychological credentials. We think that this issue, coupled with the other issue in the case involving treatment records, was devastating to Mr. Neuman, and I would move to that issue now. The state used Peter Thomas's and Dr. Julia Randorny's notes and the timing of those interviews and narratives from Mr. Neuman to create the impression that he was not really suffering from mental illness, but that this was an evolving story over time that grew with each mental health expert that he talked to. We had evidence in the case that was simply not true. In fact, filed under seal as Defense Exhibit 13 are the treatment records from the Neumans, Mr. Neuman and his wife, from marital counseling. Dr. Flores and Dr. Marks, who were the defense experts who were called by the defense, both relied upon notations that Dr. Warsaw made in treating both Mrs. Neuman and Mr. Neuman prior to the acts that gave rise to this indictment. In fact, in the record at page 2272, Mr. Peters tried to make a proffer, and he got part of the proffer into the record before there was an objection. There were five separate entries by Dr. Warsaw when he was treating Mr. Neuman that indicated that his wife had some concerns about his mental health and that they were relevant to the questions in this case. As part of the public record and as stated at page 2272, Mr. Peters proffered that Ms. Neuman says, "I think Hemy is in a deep problem. She is to have said that he wanted to kill himself and that she suspected he had a mood disorder."
Two experts testifying the other, and that has to be resolved, or?
No, Your Honor, it's really more than that. There were two experts for the defense who testified after completing a full and thorough examination of Mr. Neuman. We would submit that Dr. Crawford, who was the state's main expert who did the forensic evaluation of Mr. Neuman, also conducted an extensive evaluation. But unfortunately, because we used consultants in this case that we never intended to testify, who were there to help us develop the case, to learn about the case, to educate us about the case, because those records were turned over to the state by subpoena, it bolstered the state's idea that Mr. Neuman was malingering. And when we tried, and to make matters worse, when we tried to have our expert testify about Dr. Warsaw's observations in his treatment notes, where he noted 5 different entries indicating prior mental health issues for Mr. Neuman, there was an objection. Our expert was not allowed to talk about it. Mr. Peters wasn't even allowed to completely make the proffer on the record. He ultimately was allowed to, and of course this court has the sealed document before it, but when we tried to show evidence that this was not a story that grew over time, that there was prior mental health issues, we were shut down. Now the state has argued that we had some sort of burden to call Dr. Warsaw or Mrs. Neuman. That's simply not true. That was a statement made for purposes of medical diagnosis pursuant to OCGA section 24-3-4, and mental health professionals are allowed to rely upon hearsay from other mental health professionals, and they're entitled to list out the materials in which they relied. Repeatedly, Dr. Flores was cross-examined, and the theme of the cross-examination was this. It was, well, Dr. Flores, we have to take Mr. Neuman's word for it when he says that these were the symptoms he was suffering from. When we tried to rebut that with evidence of prior mental health issues, we were shut down at every turn. We were told that we couldn't refer to it. We finally had to resort to even make the proffer to file it under seal. For the state to be allowed to use our defense consultants' notes by subpoena, take them out of context, then suggest that this was a story that grew with each expert, and then for us to have a ruling that doesn't allow us to even go into the prior mental health conditions, we think was devastating to the defense in this case. Beyond that, this was a conviction that was secured on the basis of perjured testimony from the most important witness in the case, from Andrea Snyderman, who was the witness that the state called as their very first witness. She lied. She lied about issues that were material to the case. In fact, materiality is an element of the offense of perjury. And the court need look no further than the DA's closing statement as to what was so important about this case. What made Andrea Snyderman's testimony in this case so devastating to the defense was that she denied that there was even an affair taking place. And our experts testified that Mr. Neuman's defense, that his descent into mental disorder and to psychosis was precipitated by the very affair that the state's expert denied even having. She said that she was harassed by him.
Is that your main contention, that your client was convicted based in part on perjured testimony?
That's one of our 4 contentions, and we think it's a very important part of this case, in that the main witness, the most important witness the state called, offered perjured testimony that went to the heart of the defense of insanity.
When you say it went to the heart, as to the specific things that Mrs. Schneiderman was convicted of for perjury, at your trial, did the state argue that any of that testimony was truthful, or did it actually contend that as to the things she was later convicted of perjury, that she was lying, just like you argued?
Well, in defense of the due process part of this case, the state argues that, seems to suggest, if not completely argues, that it came as no surprise to the state or to the defense that she lied. But there's an issue in even, if that's the case, and even calling a witness that you suspect is going to lie.
Well, it's not an unusual thing for a prosecutor to have a witness who they believe is going to tell the truth about some things and lie about some things, to have a rule that that witness becomes incompetent, as opposed to the state's duty is to make clear through cross-examination and impeachment, where the problems are with the testimony and let the jury decide. As your rule that if the state knows that a witness is going to lie about a particular fact, even if they make that clear to the jury, that you can't have a conviction?
Well, if a conviction rests upon perjured testimony from such an important witness in this, and it is material, it goes to the defense, you have a witness saying that an affair never took place, that our expert is saying was the precipitating or triggering event that caused the insanity, then yes, it renders suspect, at the very least, the conviction itself. I have about 47 seconds. I would like to reserve the balance of my time.
You may do so. Ms. Cross?
Good afternoon, Mr. Chief Justice, Your Honors, may it please the Court. My name is Anna Green Cross. I represent the DeKalb County District Attorney's Office and the people of the state of Georgia in this case. Appellant is appealing his conviction for the malice murder of Russell or Rusty Schneiderman. On November 18, 2010, about 9 o'clock in the morning, it's a Thursday, Rusty Schneiderman takes his 3-year-old son to the Dunwoody Prep Daycare in his nearest home in Dunwoody, DeKalb County. He drops the child off. About 10 feet from the front door of the building, he is approached by the defendant. The defendant doesn't say anything. He doesn't take anything. He pulls out a weapon and shoots him 4 to 5 times in the chest and torso. Mr. Schneiderman is fatally injured despite the assistance he gets from bystanders and the medical attention he receives. He dies about an hour later. Appellant Neuman goes back to the car he rented in the disguise he concocted and drives away. He gets rid of the weapon, he concocts an alibi, he lies to the police when they eventually speak to him, and he goes back to work. This is the conviction that appellant is presenting to the court this afternoon, and the conviction and sentence that the state is defending. I will address the 3 issues that Mr. Key raised, and I'm going to do them, I think, in opposite order with the agreement of the court. I'm going to take the perjury issue first, because I think that's easily addressed and easily discarded. Subsequent to Mr. Newman's trial, Andrea Schneiderman was tried and convicted in DeKalb County Superior Court on numerous charges, some of which were perjury related to her testimony in Mr. Newman's trial. Other charges include obstruction of justice, obstruction of law enforcement, destruction of evidence. Andrea Schneiderman was the wife of the victim and the lover of Appellant Neuman. She was a fact witness for the state. While on the stand, she testified in several particulars, made numerous statements largely related to her relationship with Mr. Neuman and the details of their interactions, their intimacies, that were challenged and impeached by the state and by the defense. Additionally, the state presented testimony from independent witnesses, people who saw them together, people who saw them kissing, people who had evidence that they stayed in hotel rooms together while traveling out of town on business. The state presented records, phone records, emails, communications, texts between the two of them, indicating that there was a romantic relationship, a love affair. Mr. Neuman repeatedly proclaimed his love for Ms. Schneiderman, asked her to marry him. Independent evidence of the affair that Ms. Schneiderman had denied while under oath. The Appellant can only sustain or only get relief on the basis of Mrs. Snyderman's subsequent perjury charge in one of two ways. One is a due process argument, and I think Mr. Key didn't seriously argue that before the court today. I would point out that to have an actual due process violation related to the perjury, then the evidence would have had to have gone unchallenged in front of this jury. There's no stretch of the imagination by which this evidence, the denial of the affair, could have been considered unchallenged in front of this jury. Mrs. Snyderman's testimony was many things. It was dramatic, it was sensational at times, it was ridiculous, honestly. And while Mr. Key might call it important or critical, I dispute that. It was also many other things. It was challenged, it was contradicted, it was impeached, and at times it was mocked. There was more than sufficient evidence in front of this jury for them, properly charged as they were on the evidence, on the law as far as impeachment and credibility of witnesses. There was more than enough evidence, the truth, in front of them for them to evaluate the testimony of Ms. Snyderman given the other facts in the case.
Did the state expect Mrs. Snyderman to testify falsely in the way she did?
I don't think the state knew what she was going to say. There was some pretrial interviews with Ms. Snyderman where she was very consistent. There was information she had that was, unrelated to her relationship with Mr. Neuman, related to her.
Now, on the particular points of perjury that were elicited both at trial and then proved in the perjury trial, did the state expect her? Why did the state elicit the testimony if it was false?
I don't think you can say from this record any indication that the state knew she was going to testify falsely. I believe that the state did its best to encourage Mrs. Snyderman to tell the truth when she got on the stand. When she got on the stand and she did not tell the truth, the state gave her the opportunity while she was on the stand, showing her the contradictory evidence, the impeaching evidence, and encouraged her to tell the truth while she was on the stand. She didn't do that. What the state did also do, however, was provide all of this information that we're talking about, all of the information that undermined Ms. Snyderman's testimony, provided to the defense prior to trial. The state not only impeached her and called witnesses that undercut her testimony, the defense had, I call it a very good cross-examination of Ms. Snyderman. There was lots and lots of information that was contradictory to what she said. And the jury, as the fact finder, that's what you want jurors to do. You want them to take the evidence, contradictory or not, and arrive at a factual conclusion, and that's what they did. So because the state knew and provided all of the information to the defense pre-trial, enabling them to impeach the witness, as well as the state calling witnesses that undercut what she said, to present to the jury the truth, there's no due process violation. The statutory basis that the defendant relies on is OCGA 1714. I'll put that up. Mr. Key didn't talk very much about the standard, but there is a legal standard that the defendant or appellant needs to meet in order to be statutorily entitled to a new trial. One, the individual who testified must be convicted of perjury, that's clear. But there's a second requirement, and that's the one that appellant just can't touch. The determination by the trial court that the verdict could not have been obtained without the perjured testimony. That's not the same as critical, that's not the same as material, that's not the same as important, although I would argue that importance is pretty subjective. I don't know that I would call this witness an important witness for the state, but she was a witness for the state. But she was a witness for the state that didn't talk about any of the elements of the offenses that the appellant was convicted of. Of course, the trial court did not abuse its discretion in finding that there was overwhelming evidence of Mr. Neuman's guilt, and that the verdict did not meet the rest entirely on Mrs. Snyderman's testimony.
Ms. Cross, your argument is that the perjured testimony did not impede the verdict. Is that
It did not, Your Honor, it did not. I mean, it was context for the motive of the crime. It gave some information that was relevant to the crime, but relevant and material is not the same as crucial or essential. And the defendant just has not established that that was true.
What about the evidence obtained from the defense's non-testifying experts?
That is issue number one, Your Honor. The defense in this case changed their verdict from not guilty to not guilty by reason of insanity shortly after the ballistics evidence came back indicating that the weapon the appellant bought proved to be the murder weapon. When that happened, the defense noticed that they intended to call two witnesses. The state was aware that 2 other expert witnesses had interviewed and evaluated the defendant at the jail after the charges were pending. And so they drew a subpoena, and there was a hearing. The subpoena was drawn very narrowly. The subpoena was drawn asking only for the results of evaluations that were performed and that were notes from the interview with the then appellant or then defendant himself. The state specifically asked for an in-camera inspection to be sure that the notes that were turned over didn't contain any communication to or from the attorneys in the case.
I understand that, but normally when an attorney hires someone to be their agent or employee, and that person, like your investigator, goes and talks to the defendant, that's considered to have the same privilege as if the attorney were talking to the defendant. So saying, well, we didn't ask for what the attorney and the defendant talked about, which is the way you frame things and the way the trial court seems to think about it, doesn't really answer the question to me.
I think it does, Justice Thomas. If you think about where this privilege is going to come from, where is the privilege going to come from? It's the defense below raised an objection as to the attorney-client privilege, the statutory privilege. And that is very narrowly drawn. That's a very narrow privilege for all of the public policy reasons you can think of. It's an absolute privilege that impedes the production of evidence, the truth-finding function. So the communication to or from an attorney is where the statutory privilege lies.
You don't think it applies to the attorney's agents or employees?
If the agents or employees are being used as a conduit to communicate with the attorney. But that wasn't the case here. Not only was the attorney not in the room, but this interview was not in the context of Mr. Neuman communicating with the expert to go back and then the expert tell his attorney what Mr. Neuman said. That wasn't the purpose.
Counsel, let me
Yes.
offer you a hypothetical.
Yes.
Suppose that a police officer is indicted, this sort of thing's been in the news lately, is indicted for shooting an unarmed person. And the defense attorney decides to retain a private investigator who has substantial experience in law enforcement and tells that investigator, I want you to go out to the jail, talk to my client, interview them, and then come back and talk to me about whether you think we can make out a case that the shooting was justified. Would the statements the client then makes in the jail to the lawyer's investigator not be covered by attorney-client privilege?
I think that's a different situation, Justice Blackwell. I think that's different because by raising a mental health defense, the defendant has surrendered some Fifth Amendment privilege that would otherwise apply. By raising the mental health, I think it does. I think it does.
He hasn't waived it as to the attorney, right?
No, he hasn't. But the
What's your authority that he's waived his attorney-client privilege as to agents of the attorney?
I don't think I wouldn't concede that these experts were agents of the attorney. I think they were employed or they were consultants. They were hired by the defense employee. But I don't think he's got when you raise a mental health defense, say you're not guilty by reason of insanity, you subject yourself then to an evaluation by the state's expert for those purposes. You can't refuse to participate.
You get to make up your own case. You normally don't get to you get to make up your own case, and you get to get some prior information on the defense case as it will be used at trial. Mm-hmm. But what you normally don't get is the parts of the defense case that they're trying to figure out what to present at trial.
Well, with respect,
What's your best authority for that you get that?
I've got the state cited several cases from I think the Fifth Circuit, the Sixth Circuit, the Seventh Circuit, and the Ninth Circuit that the attorney-client privilege, your Sixth Amendment protection, is not affected when the state subpoenas.
The problem with all those cases, like Noggle, the case is what that case says is it's not a Sixth Amendment case, it's a matter of state privilege law.
And our state privilege law is drawn very, very narrowly.
So give me a case, what's your best state privilege law case? Because I agree, it's not psychiatrist patient privilege, it's not Sixth Amendment, but what's your best case? Because it seems like the majority view nationwide is as a matter of local privilege law, you can't get at this stuff.
I think that's, I disagree with that, and I'll cite to the court several cases. Weekly is a case that's cited by the state, that a firearms expert employed by the defense is not covered by the attorney-client privilege. Davis, a 2009 decision by this court, private investigator communicating with the defendant is not protected by attorney-client privilege. Even the attorney to the private investigator was not protected. Bryant, the Davis case cites a 2007 case, Bryant, that letters from the attorney to the client is not privileged. It's not intended to be, it was not intended to be confidential. All the public policy reasons that you can think of for why the attorney-client privilege is drawn so narrowly are appropriately applied in this case. When a defendant raises a mental health defense, the only evidence that can be found about that issue is from the defendant himself. Now, the state didn't ask for and didn't get, I think, anything that would be covered by the statutory privilege. It didn't ask for, expert, tell me what your communication with the attorney was. It didn't ask for, what did the attorney tell you? What did you go back and then tell the attorney about your interview with the defendant? What the state asked for and what the state got was the experts' results of the evaluations that they performed and notes that they took from the interview with the defendant.
So if I hire anyone, well, and I don't understand why mental health defense is unlike any other defense the defendant may raise, but if I hire anyone to go talk to the defendant as the defendant's attorney, I hire someone to go talk to the defendant, I have to risk that whatever the defendant tells them in confidence, and only because I asked that person to go talk to the defendant, that the state gets free rein at that.
I don't think Justice Knives, I don't think free reign is right, but I think that you're not, I think the proper way to look at it is what protects that? What protects that communication? And it's not work product. The information that the state asked for and received wasn't work product. It wasn't the mental impressions of the attorney. It wasn't communication between the attorney and the client. That's statutorily protected, and that's not it. In the Davis case, it was a private investigator who went and talked with a defendant, communicated with the defendant, and that was not protected by the privilege. The privilege in the Davis case cites, it is subject to the narrowest possible interpretation. And the narrowest possible interpretation, as interpreted by this court, is that it is communication to and from, actually just the statute directs only to any attorney from the client seemingly flowing up, but through an agent. If the attorney sends a secretary or a paralegal or even an investigator to the client with a question to be then communicated back to the attorney, I think that's covered. I think that's fair. I think that is within the scope of the statutory privilege. But this wasn't what that was. This was the defendant telling a version of events that was then inconsistent with what he told later mental health professionals who saw him. The evolution of the client's or Mr. Newman's psychotic symptoms was what the import of the testimony.
So you can actually make it somewhat worse by making it clear that before the defense experts who are testifying for you, somebody acting on behalf of the defense attorney went to talk to the defendant and he was inconsistent, so he must be lying. I mean, in some ways, it makes, I don't know why a defense attorney would ever hire any agent if that were your risk.
But again, I'm going to come back to how is it protected if it's not protected by a Sixth Amendment, an effective assistance of counsel?
If it's protected within the scope of the attorney-client privilege as understood in Georgia. And you're saying, so the bottom line for you is, as a matter of Georgia attorney privilege law, no one other than a licensed attorney can use an agent or an employee unless he says to the agent or employee, the only thing that'll be privileged is what I ask you to go basically as my conduit, go ask my client and have my client send it back. But don't ask anything else. So, because nothing else will be privileged. I don't know how you could ever have an expert in confidence evaluate your client.
When you are, had they eventually not raised, not guilty by reason of insanity, then this information wouldn't be relevant to the state and it wouldn't have come out.
Well, no, because let's say the reason they couldn't raise that defense is because their expert said, I talked to the guy and he admitted everything and he admitted he was faking it. So now they don't raise the defense, but under your logic, you could still go to them and get devastating evidence of guilt.
Well, there may well be a Fifth Amendment privilege attached to that or a psychiatric patient privilege attached to that.
You've argued there's no psychiatric patient because it's not for treatment, and there's no Sixth Amendment or Fifth Amendment privilege if they've waived.
What I'm arguing to you, and it's not, I don't think just my interpretation, I think that is the progression of the case law. I didn't make it up, and it's interesting to me that the defense is not able to present any contrary authority to the Weakley and Davis and Bryant, the cases I've cited to the court for a narrow interpretation of the statutory privilege. It is, it is intended to protect the communication between the attorney and the client. That's what it's intended to protect. The attorney was not in the room when these statements were made. There is no evidence that the statements were then conveyed back to the attorney in the way that or were intended to go back to the attorney. The state did not ask for any work product, any impression of the attorney. I don't want to know about any strategy they developed as a result of it. All the state was, thank you, Your Honor. The attorney-client privilege protects only the communication between the attorney and the client, not the communications that prove important or inform the legal advice, just the communications between the client and the attorney.
Thank you very much.
Thank you.
Mr. Key, any rebuttal?
Yes. This is the form. Basic expectation was that there was going to be a report that was going to go directly back to the attorney. Beyond that, Your Honor, the agents are included. They are part of the team of experts. And if the state is right about this, if the state is right about the way the law either does work or should work, then I can't imagine where any attorney who has concerns about a client with mental health issues would ever send a consultant out to the jail to interview the client at the risk of that person's entire file being turned over to the state. Your Honor, those cases, first of all, I'm happy to provide a supplemental brief on those issues. Those cases have to be read alongside of Taylor versus Taylor, which I've cited in the brief, Fire Association of Philadelphia versus Fleming, which is a very old case, and the Georgia Rules of Evidence that include, or even this court's, the concurring opinion of Justice Sears and Davis that says the attorney-client privilege includes, by necessity, the network of agents and employees of both the attorney and the client acting under the direction of their respective principals to facilitate the legal representation. If you look at Exhibit 101, that's exactly what the expectation was, and that's why attorney-client privilege was breached in this case. We would ask that the conviction be reversed.
That answer your question?
Yes, thank you.
On behalf of the court, let me thank both sides for your excellent presentation. We're going to take about a 10-minute recess. I know there are a large number of electronic media people are here. It'll give you an opportunity to break down your equipment if you'd like to do that. I understand there may be another case where there's some media interest as well, and that would afford an opportunity for those people set up if they wish to do so. We'll rejoin you in about 10 minutes and hear the last two cases for the afternoon.
All rise.